So Anthony Kennedy had surprised everybody by voting with William Brennan on both of the legal issues involved in this case. But he had rapidly demonstrated that his vote was shaky by sending that note to William Brennan about the historical inaccuracy he perceived in one of the amicus curiae briefs. Brennan responded very diplomatically. He sent Kennedy a note in which he thanked Kennedy for his criticism. And he says it didn't really matter because he wasn't planning on focusing on the amicus curiae briefs when he was writing his own opinion, but rather he would be drawing upon the court's own previous cases, their own precedents for the historical analysis. And so even if Eric Foner was wrong, it didn't matter because that wasn't going to be part of his opinion. Another thing that Brennan did, and this was unusual, is that he sent a copy of his completed first draft to Kennedy ahead of anybody else. This is unusual because typically the justices send a copy of their completed drafts to all of the other justices at the same time. But in this case, he sent it to Kennedy only. He did this for a couple of reasons. Number one, it's very gracious. It's a sign of respect. And so he wanted to have this very personal sort of gesture to Anthony Kennedy. But there was another reason for that, and that is if he gave it to Kennedy first, then the other conservatives couldn't criticize it because they hadn't read it. And so this was a way to allow Kennedy to hear what Brennan had to say without hearing any competing arguments. So at this point, Kennedy is still on board, but he read Brennan's first draft, and then he writes a criticism of that draft. Now, the first 2/3 of the opinion was about whether or not the court should overturn Runyon v. McCreary, and if you'll recall, that's the issue that the court had decided 9-0 not to overturn Runyon v. McCreary. So this was the easy issue. Even this part of the opinion that was decided 9-0 and that wasn't very controversial, Kennedy made several criticisms even about this part of the opinion. Brennan addressed those. He made several changes to address Kennedy's concerns. The last third of Brennan's draft focused on the most controversial part, the part of the decision that had been reached by a 5-4 vote, and that was whether or not discrimination in employment is discrimination in the making and employment of contracts. And on this particular issue, Kennedy said that he had a fundamental disagreement with William Brennan. So in other words, he was going to vote the same way, but he wanted a different legal theory. Now, please try to understand, because it's a very subtle difference. What was the difference between Brennan and Kennedy? They were both going to vote for Brenda Patterson, but they had very different ideas about why. Brennan argued that any acts of discrimination that occurred after somebody was hired are indeed illegal under the Civil Rights Act. This was the straightforward position that Brenda Patterson wanted the court to adopt. Kennedy didn't agree with this particular position. He disagreed. He said that acts of discrimination that occur after somebody's been hired are not illegal under the Civil Rights Act. So this is a fundamental disagreement. So why was Kennedy still voting in favor of Brenda Patterson? Well, he argued that the act can be used in employment discrimination cases, but only if the employer intended to discriminate at the time the hiring occurred. So if somebody was hired in a non-discriminatory way and there was never an intention to discriminate against them at the time they were hired, and then later they were discriminated against, that would not be covered by the Civil Rights Act. But if they did intend to discriminate at the time of the hiring, then Brenda Patterson could bring her case. Now, this is the very subtle part. Kennedy did agree that anything that happened to Brenda Patterson after she was hired would be relevant, but not illegal. The things that happened to her after she was hired were not illegal, according to Kennedy, but they can be used as evidence that the employer intended to discriminate at the time of hiring. So Kennedy's argument is that nothing that happened after the hiring decision was illegal, but the things that happened after the hiring decision might shed light on the motives for why the person was hired. So if they suffered from a lot of racial discrimination, it might be evidence that there was discrimination at the time of hiring. So it's a subtle difference, but an important one nevertheless. But in either case, Brenda Patterson would win. So in legal language, here's what Kennedy was saying. Acts of harassment that occur after the parties enter into a contract should have only evidentiary value on the issue of whether the contract was made in good faith, and should not give rise to an independent cause of action under Section 1981 if it is otherwise shown that the contract was made in good faith. So this was the dispute between Kennedy and Brennan. But based on Kennedy's criticisms, Brennan makes several more changes to his opinion. Anthony Kennedy then sends Brennan another note, and he seems appeased. He seems as though the changes will satisfy him. In light of the changes you've made to accommodate me, however, it seems unlikely that our differences would lead to divergent results in many cases. For the sake of having a court on this important issue, I believe I can set aside my reservations and join your draft, although I wish to have the benefit of whatever comments and suggestions our colleagues will have after full circulation. So Kennedy, of course, is saying, I appreciate the changes you've made. I'm still going to join with you, but I might change my mind after I hear what the other justices have to say. It's not a great vote of confidence. And then the tide begins to turn. Brennan's newly revised opinion was then circulated to the rest of the court, and then, right afterwards, William Brennan had to be admitted to the hospital for emergency gallbladder surgery. This meant that William Brennan was sidelined for several weeks. He was in the hospital for several weeks, which meant he wasn't in the court. He wasn't writing opinions. He wasn't responding to criticisms. And while Brennan was recovering, on April 7th, Anthony Kennedy circulated a new opinion. In this new opinion, he still agrees that Runyon should not have been overruled, so he agrees with William Brennan and Brenda Patterson on the first issue, but now he's changed his mind, he's changed his vote, and he's now dissenting on the second issue, on whether or not the Civil Rights Act applies. And of course, if he's now dissenting from that issue, he's not dissenting anymore because it's gone from a 5-4 vote in favor of Brenda Patterson into a 5-4 vote against Brenda Patterson. So in fact, he calls it a dissent, but it's not a dissent anymore because he's now on the majority side. The dissent has become the majority on this issue. And of course, this results in another note from Anthony Kennedy. He says, Dear Bill, as you must have surmised by now, my remaining doubts about your fine opinion in this case did not go away, though I had hoped to work through them. You are indeed a patient man. Sincerely, Tony. Well, this set Brennan off. He now tried to salvage things, as Brennan often would do. Brennan would rather win something than lose everything. And so Brennan rewrote his opinion, and in his new opinion, he argued that Brenda Patterson should lose So Brennan is now ready to switch not only his opinion, but he's ready to switch his vote. And he adopts Anthony Kennedy's argument. He argues that her problem was that she didn't use the acts of discrimination that happened after she was hired as evidence that the company acted in bad faith while hiring her. This is exactly the argument that Anthony Kennedy was making, and so he was endorsing her legal theory. Now, why would he do this? The reason that he did this is because even though Brenda Patterson might lose in this particular case, this might still let some future litigants win. It wouldn't foreclose all future litigants from using the Civil Rights Act of 1866. So it would be a partial victory rather than a whole victory. But the plan backfired. William Brennan was not as smart as he thought he was in many instances. First of all, he never should have assigned this opinion to himself. He should have assigned it to Anthony Kennedy. And this new opinion backfired because Kennedy was not appeased, and in fact, he writes a new draft that starts to attack Brennan's draft, and it starts to attack even the parts of the draft that Kennedy formerly agreed with. So Brennan's draft seemed to push Kennedy farther away rather than bringing him closer. Not only that, Byron White writes an opinion that criticized Brennan's logic. Brennan's opinion will surely shock Mrs. Patterson, McLean Credit Union, the Solicitor General, and 16 other amici who filed briefs here, none of whom ever suggested any defect in Mrs. Patterson's pleadings or in the presentation of her claim at trial or on appeal. With all due respect, just as Brennan's proposed ending to this lawsuit is as unsatisfying as the conclusion of a bad mystery novel. We learn on the last page that the victim has been done in by a suspect heretofore unknown for reasons previously unrevealed. So he was accusing Brennan of what Rehnquist had actually done, which is raising a legal issue and making a legal argument that nobody had ever raised in the case, and that's something the court should not do. Kennedy did make one change in his opinion. He, as the court often does when it decides against civil rights litigants, it tries to pretend like it actually cares about those civil rights litigants. And Kennedy did that by paying lip service to civil rights, in his opinion, by saying the law now reflects society's consensus that discrimination based on the color of one's skin is a profound wrong of tragic dimension. Neither our words nor our decisions should be interpreted as signaling 1 inch of retreat from the court's policy to forbid discrimination in the private as well as the public sphere. So what Kennedy is saying is, oh yes, we are deciding against Brenda Patterson today, but that shouldn't be interpreted to mean that we don't care about discrimination. Well, Brennan didn't agree. He says, the majority conducts an ahistorical analysis that ignores the circumstances and legislative history of Section 1981. The fact that Section 1981 provides a remedy for a type of racism that remains a serious social ill broader than that available under Title VII hardly provides a good reason to see it, as the court seems to, as a disruptive blot on the legal landscape, a provision to be construed as narrowly as possible. In other words, the court here doesn't like Section 1981 because it helps fight discrimination. That's what it's supposed to do, and it does it well, and the court doesn't like it specifically for that reason. Now this got nasty. This was getting very personal, and John Paul Stevens, who was one of the liberals who was on William Brennan's side, he interceded. He thought this was getting out of control, and he wrote a note to William Brennan. He asked Brennan to soften some of his language, otherwise he might have to dissent from some of Brennan's opinion. He said that he would join part of Kennedy's opinion, although he wouldn't change his vote. He said he would never vote in favor of McLean Credit Union, but he would join some of Kennedy's opinion, making it even a stronger majority. And ultimately, Brennan softens his language, and Kennedy softens his language, but the result doesn't change. And so, the result, Brenda Patterson wins her first issue. Runyon v. McCreary was upheld, but again, this didn't really matter to her because that was the way it was before she brought her case, so she simply won something that had already existed. And even though the court upheld Runyon, they narrowed its scope and they reduced dramatically the number of cases in which it could be used, the contexts in which it could be used, possibly reducing it to being completely ineffective. And so Brenda Patterson ultimately lost this case, and it was seen as a major defeat for civil rights litigation. But of course, the importance of this case for us in this class isn't the law so much as it is the process and the importance of the opinion assignment and the interplay between the justices, and of course the fact that the votes are tentative and they can change at any time, even changing the outcome of the case. And of course the role of one individual justice to shape the law, the newest justice, Anthony Kennedy.